On June 21st of 2023, and this is what no victim has testified about or spoke about, not subject to testimony or to cross. Mr. Voga stood up in this court and said, well, nobody was hurt or something along that line. And I stopped him. And I said that I will be judicial. That doesn't have anything to do with this case. Whether somebody was hurt or not doesn't matter. What we heard from Assistant Chief Lamont is that there were 2 ambulances and fire engines that were called to Valpo High School. So think of this. And what we heard from Mr. DiCarlo is, as a trained law enforcement officer, somebody comes in with guns and they start shooting people by accident. Then you have little kids, less than 12, shot and killed by someone responding to a fake bomb threat. But what I said to Mr. Voca in June of 2023 was, there are 2 problems when ambulances and fire trucks, not to diminish law enforcement officers, but when they come to a bomb threat, is this. They could get into a car accident as they're speeding to rescue someone. And worse, at that point, if a house is on fire or if somebody needs an ambulance, the fire engine is at the high school and not going to put the fire out. So as far as we know, there weren't any other people who were actually harmed as a result of ambulances not being available or fire engines not being available, but the community was victimized by this, not just the schools. That's one thing. And I disregard a lot of what Mr. Voga says. It's his job to be a lawyer and he says things. But on April 16th of 2025, I sat right here as Ryan was sitting right there. Mr. Voga was there, and Ryan Krajewski, at that point, or give or take, 19 years old, pled guilty, despite the fact that his lawyer was telling him not to. That's either remorse or he doesn't believe in his lawyer or stupidity. One of the door number 1, door number 2, or door number 3. So I've heard a lot of predictions and I've heard a lot of psychological analysis by 2 lawyers and a probation officer, none of whom are psychologists or therapists. I give their statements whatever weight they're worth. There is in the record evidence from a therapist or psychologist or mental health professional. But I'm going to explain what I give the most weight to, as I'm required to do under the law. So under the law, if I can find my notes, I'm required to say this. I accept the plea agreement as written. I enter judgment of convictions under counts 3, 4, 5, 6, and 7. The sentences in those counts will run consecutive with each other. They will run consecutive. I'm going to explain in greater detail. They will run consecutive with each other because there were different schools and different victims involved. And I started off by saying the entire community is threatened by not having an ambulance. The law, though, says that the maximum sentence that could be imposed for a level 5 is 7 years. Based upon that, The sentences in counts 3, 4, and 5 run consecutively with each other. Counts 6 and 7 are concurrent with each other and also concurrent with count 1. I find I'll set forth the aggravators and mitigators, which I'm required by law to do, and then I'll set forth the actual sentence and the condition, because I've told you how the sentences will run. I find as an aggravator, the defendant does have a criminal history which predates this, as well as an act that allegedly occurred on January 26, 2023 in Lake County, Indiana. So I find as an aggravator that the defendant's criminal history. I find as mitigators that he did plead guilty over his lawyer's objection, which I've never seen. And again, I said that's either bravery or stupidity, but he did it. He did it here. I truly do find that the defendant's youth is a mitigating factor in that he's now 19 years old. And he was 16 at the time that he admittedly committed these offenses. I find as mitigating factor in part, but in part it scares me, the defendant's mental diagnoses. And I will explain that in greater detail without getting into the specifics of the mental health, but it was admitted as part of the evidence. Dr. Yannick wrote the court and indicated that the defendant suffered from oppositional defiant disorder, which is an explanation, but it scares me. And I will explain why that is, because if he had or has oppositional defiant disorder at some time, then maybe he'll have it in the future and he'll oppose and defy. So I don't give that much weight. But as I continue to read, I'm not a psychologist, but to use language that most of us can understand, what has happened is he's grown up in that his diagnosis has changed in this letter. The May 2023 letter that included the word hilarity that Ms. Ryan asked to be admitted was admitted. That letter dated May 2023 from the Porter County Juvenile Detention Center had that word. It was allegedly sent to somebody in England. The defendant was 16 years old at that time. So those are the aggravators and mitigators that I have set forth, and I've said which counts will be concurrent, which counts will be consecutive. So the question then becomes is, should he go to prison? And if so, how long? And if not, what should he do? And for how long? So and why? Everybody that's spoken has tried to say, well, this is what's going to happen. We think this is going to happen. We think that's going to happen. We don't know. We hope, we pray that Ryan Krajewski, now 19 years old, doesn't do this anymore. All of us in this room hope that. Everybody has predictions, but if that's the case, we could all win the lottery. So the only thing that I can base anything that's happened is going to happen in the future is what has happened in the past. So you could go back and say, well, he started committing crimes when he was 13, and he was really smart and he knew computers when he was 13. All that is true. I accept that is true. I accept it's true. He writes a letter in May of 2023 from the JDC to England and has the word hilarity in it. Mr. Voga talked about Ryan Krajewski being waived from juvenile court